We hear this all the time. Adult children know that their parents' trust is outdated or even just a total mess, but the parents don't want to deal with it. They say, oh, it's probably fine, or lawyers are too expensive, or they just don't want to think about it. If this sounds like your family, you are not alone. In this video, I'll walk you through what does work, how to start the conversation, how to get a second opinion, and how to ultimately move forward even when your parents feel stuck. And if you want more information on how to navigate these tough family situations, make sure you're signed up for our newsletter. So a lot of adult children reach out to our office. They just know their parents' trust is outdated and it's going to create a mess for them when their parents pass away. Maybe the parents have told their kids that yes, they've titled everything in the name of the trust, but the kids aren't sure. And if the parents didn't do it right, you know that this could lead to a probate administration or just a costly court petition. Or maybe the parents created their trust 20 years ago when estate tax laws were very different and their trust splits into two subtrusts that now is unnecessary. By the way, I talk about this more in my video, Should I Simplify My Trust? In fact, I've made a video of many things that can go wrong during the trust administration process when your trust isn't properly drafted. That video is called Warning: Horror Stories of Trust Administration. Maybe you watched this video and now you really want to make sure your parents don't let this happen to you. But your parents may be hesitant to revisit the trust. Here are the main objections that we've heard from parents. The trust probably works fine. We call this the hoping and praying method. Attorneys are too expensive. Our estate planning attorney retired, and we don't know who took over the matter. How do we know we can trust that new attorney? And sometimes they say, it's really hard to understand this stuff, but the lawyer said it was fine 20 years ago. Basically, they have their heads stuck in the sand. Yes, we've heard all of the objections. So I'd like to share some approaches that we've seen work with different families. Of course, only you know your parents the best and what might work with them. First, I suggest you warm up your parents to the subject by sending them interesting information that they can review at their leisure. It can be hard for people to trust lawyers. After all, as a profession, we don't really have a stellar reputation. So it's really helpful to introduce your parents to the lawyer of your choice in a non-threatening manner. I and my firm, we have over 200 YouTube videos. Here are some videos that you might want to send your parents. One of them is Should I Simplify My Trust, which I mentioned before. Another one is called Estate Planning Isn't Just One and Done. And then we have a video, Why We Rewrite Trusts Instead of Just Amending Them. Next, if your parents still won't cooperate, you can pay an attorney hourly to look over their trust if they've given you a copy. And the attorney can give you their opinion on how airtight they think that trust really is. Now, in this situation, typically the attorney isn't representing your parents. They're representing you as a potential beneficiary and maybe a successor trustee of the trust. The attorney can mention points that they think might need to be changed, and you can bring those points back to your parents and propose a way forward.
Did you know my mom has a monthly newsletter where she shares helpful information? Click below to join.
Now, maybe your parents are willing to have one meeting, and if they are, definitely set up a meeting with that attorney. Usually you can join the meeting and you can offer to pay for the meeting. For a lot of us, our grandparents went through the Depression and they taught our parents not to spend any money. They think spending over $1,000 for legal assistance is highway robbery. But you understand that paying for skilled representation pays for itself many times over in the future. Yes, you can pay for someone else's legal fees. In this situation, we at our firm would prepare something called a third-party payor letter. This states that one party is paying us, usually the children, but that our clients are the parents. And we're following the parents' directions and representing the parents' interests. That way, it's clear to everyone that the child who's paying for it is not influencing the attorney's judgment. And that's especially important if the parents have more than one child and that other child might be concerned, hey, why are you taking dad and mom to that attorney? What are you trying to do? The third-party payor letter is really important in that situation. Finally, if you as the adult child, if you have a larger estate, or if you want some asset protection built in, You might want to have your parents set up a dynasty trust for you, so your inheritance passes outside of your estate. Or maybe you want your parents to leave your inheritance directly to your kids and to skip over you. You can coordinate all of these things when your parents are on board. We call this multi-generational planning. We're making sure that planning works through all the generations. And this is a beautiful thing when it's set up and executed properly. So you don't have to sit back and just hope that everything works out. You can take small, strategic steps to avoid a future mess. If this video hit home for you, check out our videos on when to update a trust and how we work with families just like yours. And if you're ready to take that first step, click the link below to schedule a consultation. We're here to support both you and your parents.
If this video is helpful for you, share it to someone else who might benefit from it.